Counsel ready to proceed?
Yes, Your Honor. May it please the Court, Elliot Shurker and Daniel Sampson on behalf of Lorillard. This appeal presents a question of law. When does prejudgment interest begin to run on an award of attorney's fees under the Florida Offer of Judgment Statute and Rule 1.442? The trial court ruled that interest starts upon entry of the judgment exceeding the offer by 25%. That ruling might have been correct before the 1996 revision of Rule 1.442, but it cannot be correct now. The two Florida decisions that have addressed the issue since the 1996 amendment support our position. The Second District's decision in Hill-Rogel says in so many words, entitlement to attorney's fees based on an offer of judgment is not determined for the purpose of assessing interest on the fees until the entry of the judgment making the determination of the entitlement to such fees. And then the Fourth District, very briefly, in the Parsons decision in 2001, applying quality engineered, held that the court should also award interest which is accrued since the date of the order determining the party's entitlement to fees.
All right. Does the date of filing of the lawsuit have any effect on this case?
No, sir. The 1996 rule governs. So why are these decisions correct? French notes that there are situations in which the right to obtain fees becomes fixed upon the occurrence of certain specified identifiable events, and she's right. For example, a determination that a party's position is frivolous or that an action is frivolous under Section 57.105 fixes the right to recover fees as of the moment of that determination, and interest accordingly starts to run at that point. A classic prevailing party situation would be another instance in which the right is fixed, and anything that the court does after that is completely pro forma, recognizing the legal significance of the event that has already occurred. But that is not the rule when there must be a predicate ruling by the trial court to determine entitlement to fees.
Why does there have to be, when you say predicate ruling, are you really referring to the judgment and the jury verdict and judgment, or are you referring to a specific legal ruling on entitlement to fees?
I'm referring to a specific legal ruling on entitlement to fees. There are essentially two categories of cases. There are cases in which, or situations, if you will. There are situations in which an event triggers the right to fees.
And that's the situation we have here, isn't it?
Oh, sir.
Why not? The statute and the rule both say entitlement. They say if X and Y happen in terms of the offer being made and the judgment being in a certain amount, then there is, and they use the word, entitlement.
It's because 1.442 was amended in 1996 to create certain absolute prerequisites to a valid offer. What French does is she confuses the prerequisites to a valid offer with issues such as reasonableness and good faith, which we acknowledge that to that extent TGIF still controls. And those are back-end issues. Those are almost affirmative defenses. But validity is not an affirmative defense. And I'd refer the Court to three Florida Supreme Court decisions on the post-1996 rule, all of which are cited in our brief. The Campbell versus Goldman decision from 2007, in which the Court said at page 227 that for an offer to be valid, it must state that it is being made pursuant to the statute. This is a mandatory requirement for this penal fee-shifting provision. Because the overall subject is in derogation of the common law, all portions must be strictly construed.
But that's not really in dispute, is it? I mean, it's acknowledged that it was a valid offer.
Judge, we disputed it was a valid offer. We fought for a long time over whether it was a valid offer. And we lost. And we were entitled to dispute that. And the balance is that they get their fees for litigating entitlement during that period of time. We fought entitlement, not amount. We also fought good faith and the rejection of the offer, but that's not what's on the table here.
So you acknowledge that good faith versus bad faith is a condition subsequent. That's something that would divest you of entitlement.
We're talking about.
But you're saying that your arguments in the record, objections to qualification under the OJ statute and rule, that's what we should look at. And because those were raised, entitlement does not occur until those have been determined.
Entitlement occurred in April 2007 when Judge Smith ruled that they were entitled to fees at the end of the fight over entitlement.
I can't really see it that way unless you show me where there is some specific argument directed to the validity of the offer.
Let me refer the court to pages 8 through 9 of our brief, where we cite exactly what our position was. Refer the court to page 2880 through 82 of the record on appeal, in which we disputed the validity of the offer. Here's what happened. There was an offer of judgment to settle something like number of thousands of cases. And there were letters back and forth after the offer of judgment was made. We took by different lawyers in the case. It was essentially, if you settle now, we'll settle with you now. Otherwise, you're going to have 10,000 cases and you're going to be liable for millions and millions of dollars. We argued that the subsequent letters varied the offer. So the offer was no longer clear and unambiguous. That said, at 880 through 84 of the record on appeal, the transcript of the hearing of January 8, 2007 appears in the record at pages I'd refer the court to are 3513 through 3517, where we argue that the offer's terms were ambiguous as to whether we could settle cases on an individual basis or whether it was an all or nothing award. And there was a conflict between the initial offer and the subsequent letters. We lost that battle and we settled. We paid them their fees, and we're only disputing interest. But we fought entitlement. We said this is an invalid offer. The Supreme Court of Florida says that an offer must be valid. It must be valid because it must be specific. It must be clear. Lamb, for example, it has to apportion between individual parties. The Supreme Court of Florida held in the Nichols decision, which is cited in our brief. The district courts have consistently held, and we agree, that proposals must clarify which of an offeree's outstanding claims against the offeror will be extinguished by any proposed release. That was exactly what we thought about. Is it 10,000 cases we have to settle? Is it one case that we have to settle? We're unclear as to what the plaintiff is offering. The last line of the opinion, or the penultimate line, if you will, because State Farm's offer failed to do so, it is invalid under Rule 1.442 and cannot support an award of attorney's fees under the offer of judgment.
But that's when it's invalid. When it's found to be valid, isn't it logical that then attorney's fees would run from that moment, the interest rate?
So if you fight entitlement, which you're entitled to do, and you lose.
If you win, then it's a non-issue.
But if you lose, the penalty goes back to the original date of
the judgment is now found to be valid.
The problem is the offer of judgment. It has to be a judgment. The offer of judgment statute is triggered by a judgment.
I understand.
The question is whether it's a 2002 judgment or 2007 judgment.
But the problem I'm having is,
that's quite a gamble you'd be asking lawyers to take in fighting an offer of judgment, Your Honor. No case law supports that.
It's not a penalty. The problem I'm having is Argonaut is something that you're entitled to because you've incurred an obligation or you pay an obligation and time is running. And we want to incent the parties to get this decided quickly rather than 5 years later, for example. So with Argonaut and the basic principle of prejudgment interest, it's not a penalty at all. So why shouldn't the rule be that if you lose on validity, your only out then is on bad faith, good faith?
Because you're double punishing us. Remember, Judge, if you're fighting about amount, the plaintiff doesn't get to recover fees for litigating amount. So the only way to make them whole in any respect is to have prejudgment interest run from the date of entitlement. Remember, that's what quality engineers is all about. Does it run from entitlement or does it run from determination of amount? So the Supreme Court divided it up between entitlement and amount. If you can litigate entitlement, but if you litigate amount, you're going to be stuck with a prejudgment interest going backwards, Judge Cortinez. But if you punish us for litigating entitlement, then you double reward the plaintiff because we have to pay fees for their litigation of entitlement. And we would also then be penalized by having lost the gamble, if you will, on fighting entitlement. That can't possibly be. If they were not entitled to fees for litigating entitlement, then there would be an equitable argument there, but you'd be giving them fees for litigating entitlement and prejudgment interest going back to the date that we were fighting about. And what you would do would be to discourage exactly what the Supreme Court of Florida said you should do as the offeree, which is to litigate the validity of a judgment. Now, if you litigate in bad faith, you're going to get whacked under 57105 in addition. So there are a number of procedural barriers that would preclude a bad faith litigation of entitlement. What we did was, actually, Judge Salter, what you suggested is we settled on the fees and said we'll just fight about interest. And once entitlement had been determined, we never litigated amounts.
I think, and that's certainly salutary, that part of the settlement, but I guess the issue here is why should litigation over entitlement be anything more than a very short hearing? I mean, you're just talking about an offer and an acceptance, and was the offer specific enough? It's not years of litigation or fees.
The years of litigation, respectfully, have nothing to do with the legal issue. Now, we've got a who shot John fight going on between the sides, which the trial court never resolved based on its legal ruling, and which there's no reason for this court to resolve because, quite frankly, it wouldn't make any difference. Everything's in the record. We go through it in exhaustive detail in our brief as to what happened between 2002 and 2007, including our appeal, our entirely unsuccessful, but certainly an appeal that received a lot of attention from this court in this opinion on the legal issues in the case. And then there was fighting about whether Judge Hubbard should hear it or Judge Smith should hear it, and I'm sure that Mr. Weinstein will go on at great length about that. It's got nothing to do with it. It wasn't heard, and when it was heard, we lost on entitlement. If there was a whisper in the record that it wasn't heard because of any bad faith tactics on our part, their remedy was under 57105. And we were held liable for all of their fees during that period of time. So we were, to the extent that we were punished by daring to fight entitlement, we were punished by being awarded fees. But the final answer to the questions that Judge Cortinez and Judge Salter, you're both asking me, is this court's decision in Cincinnati Equitable Insurance. Because in Cincinnati Equitable Insurance, what happened was...
Well, but Cincinnati Equitable is another in the line of cases on entitlement, and this happens to be an insurance case. But 627-428 doesn't use the magic term entitled, nor does the language of Cincinnati Equitable, which says when fees are going to be set in an arbitration or by order. Here, the language of the settlement statute and rule really talk about entitlement if X and Y occur.
If X and Y
kind of self-execute.
A valid offer. A valid offer. It's no, under TGIF, there's no question it was X and Y. As a matter of fact, that's the language in TGIF, is that there are two, it's almost exactly as you said, Judge Salter, there are two things that have to happen. There has to be an offer and you have to beat it by 25%. I mean, Justice Overton's opinion says that in almost so many words. But what's changed is that the rule was amended in 1996 to require a valid offer, which is separate and distinct from an offer, questions of good faith, or the reasons for the rejection of that offer. But and Judge Salter, the statute in Cincinnati Equitable is actually about one paragraph long. It's 626.911. And what it says is that in an action for breach of contract against an insurer, a foreign insurer, an alien insurer, if the insurer or person representing or aiding such insurer has failed for 30 days after demand prior to the commencement of the action to make payments in accordance with the terms of the contract, the trial judge shall allow to the plaintiff a reasonable attorney's fee or compensation and include it in the judgment. But what this court held in Cincinnati Equitable is that the prejudgment interest ran from the date that the court determined entitlement under the statute. So to hold otherwise under the rule, when the Supreme Court of Florida has said not once but at least 3 times that a defendant may challenge the validity of an offer that doesn't touch every single nook and cranny of 1.442, because of course it's in derogation of common law, it has to be strictly construed, the offer is invalid. And to reach back, if you lose that battle, would be to allow the plaintiff to doubly punish the defendant, and of course the effect of that would be, to use your word, would disincent the defendant from ever challenging entitlement. Because the risk of interest.
I'm challenging your time only because you're over, but we'll give opposing counsel extra time if needed, and you'll still have a minute for rebuttal.
To that challenge, I'll bow my head, Your Honor.
Okay.
Good morning, Your Honors. I'm Marvin Weinstein, and along with Frank Anselm, we represent, of course, French.
Could you speak a little bit louder, please?
Yes. Usually I'm accused of the opposite. I'll try my best.
I'm getting older. My ears are getting harder to hear. So.
First of all, let me just say something to you about the valid offer. In the trial court, the lawyer representing Lorillard, Mr. Riley at that time, was asked this question by Judge Smith. And just so it's clear to everybody, you do agree that if I rule that there's nothing other than the proposal itself, that I should consider that the proposal itself does comply with the rule. Right.
What page are you quoting from?
I'm referring to page 39 of the transcript of the January 18, 2007. And she's saying, look, Judge Smith is saying, don't I just consider the four corners of the offer? What you're saying is I'm supposed to consider what some other lawyer said to the Lorillard during negotiations. It was Miles McGrain who was negotiating or talking with the lawyer for Lorillard, and their position all of a sudden became, well, because of what Mr. McGrain said, who didn't represent French. I represented French. Because Mr. McGrain was talking with the lawyer from Lorillard, we understood him to say we must settle all the cases. But Mr. McGrain never said such a thing. Indeed, he filed an affidavit expressing his outrage at such a suggestion. And actually,
let me ask you to address, because I think we have the point on the sufficiency of the offer, and we are able to look at the offer and compare it. But here's the harder question, I think. The trial judge in this case ran the interest from some point in 2002, I think September, when the jury reached its result. But doesn't the quantum of fees include amounts that were between that 02 date and 07? So that, in effect, isn't the trial judge awarding prejudgment interest on amounts which post-dated that effective date?
I think the law is clear that we only get interest on the attorney's fees that are determinable as of that date that the judgment was entered. That's clear.
So that the $150,000 for the appeal, or whatever amount it was, those amounts that are shown in the fee application or the motion for fees to have been after this jury award date, all those fees then were excluded in the number that was...
Right, because that wasn't determined yet. It was, you see, that's what the case, TGIF says that to begin with, the word shall be entitled cannot possibly have any other meaning other than to create a right to attorney's fees when the two preceding prerequisites have been fulfilled. One, the party served the offer, and number two, the party recovered more than, the judgment was entered for more than 25%.
And any time you have that situation, then it's Argonaut and it's a liquidated amount, and you just calculate.
And this court has really decided it already. By that I mean on Mason, the same concept. Mason versus Ryder. That case is absolutely right on point in terms of what we're here about. In that case, you remember Jackie Mason, the comedian. He was accused of, or there was a lawsuit against him for paternity. And the statute says, just like in this case, if the court decides that the father is the father and the judgment is entered, then the mother is entitled to attorney fees. At the end of the case. So what happened was, the judge did not award interest on the attorney fees. And this court, Third District, finally, the mother contends that the trial court erred in failing to award prejudgment interest on the attorney fees from the date of the judgment of paternity. We agree, citing Ignacio, by virtue of the the settlement triggered the plaintiff's entitlement fee. In this instant case, the father's liability for attorney fees was determined after a judgment on paternity. It was the April 26th of 88 adjudication of the paternity which triggered the mother's entitlement to and the father's liability for payment to attorney fees. That event fixed the date of the loss for purposes of awarding prejudgment interest on previously incurred attorney's fees. And that's why I say Judge Salter, as of that day, when we got a judgment entered for 25% over and above our offer, as of that date, we were entitled. And that's really what Judge Stenton wrote. As the cases say, he said it would make, if I didn't give interest, it would make a mockery of the statute. And he said to opposing counsel, he said, are you saying that you can just go ahead for years and just contest and argue entitlement, etc., and you have interest free? That's just what Ignacio and all those cases say. You're not being penalized. You're penalizing the plaintiff from keeping him from getting the use of the money from the date he was entitled. I mean, Lorillard's lawyers got paid instantly. They got paid back when we got the judgment in 2002. They were paid all of their fees. And we were entitled to our fees at that time. They had the use of the money, and that's what the cases say. Now, because they say that they are not allowed to just raise issues of entitlement or bad faith just so that they can delay. And remember now, this actually was a case in which we got a $5.5 million judgment. The judge reduced it to $500,000. I know you know all this. We accepted it grudgingly and said, all right, now pay us the money. Pay us the money. No, they just appealed it to the third district. You know, they got almost a year delays in Elliott, with all due respect, got 30-day extensions, then went to the Supreme Court, and so on and so forth. All this time, of course,
you all got 11% on your judgment amount, which is hard to get in these days.
Well, we did get, I don't remember what the stock market was doing at that time, Judge, so I don't know if we were ahead or behind. The point is this: Tallahassee, I know you're familiar with the Tallahassee case. That case, the statute in that case said, if you get a judgment, it was a Mednow case, it read the same as this really. If you get a judgment, you shall be entitled, again, in a Mednow case, you shall be entitled to attorney's fees. And the exact issue. The court ruled you're entitled to interest from the date the judgment or the verdict came in. So too in Mason, the same thing. Now, we talk about quality. I have to tell you that the quality, it's the Supreme Court affirmed and approved of Mason, Brentsky, and Vickery. All of those at First, Third, and Fifth District all say you're entitled to interest from the date the judgment is entered. Indeed, even in 57-105 cases, they don't have necessarily hearings on whether you're entitled, a separate hearing on entitlement. They say when the judge enters a judgment that there was no justiciable issue, you're entitled to attorney's fees and interest from that day. Even though the judge, you don't even have require a separate hearing on that. Furthermore, the statute, the first part of the statute talks about you shall be entitled to attorney's fees. The second part of the statute then talks about both the issues that they raise. In other words, bad faith, whether the offer was made in bad faith. Every single one, I tell you, every single one of the issues they raised was really frivolous. First, they said the offer was too little. Of course, you know what Judge Smith said about that. Hey, that may apply to a defendant making an offer. How can you say what, the plaintiff should have offered $50,000? That was okay, but they only offered $3,000, so why don't you just take it? Then they said, oh, but it was to amass a war chest to use against the other defendants. And well, first of all, they say it's too little, then they say it's a war chest. And then they go on and raise all these issues that, he only made it to one defendant to use the funds against the other defendant. Well, there are cases, the Hess case, etc., and I filed I actually filed a motion to strike their memorandum because everything that they suggested, there either was a case on point or really didn't make sense. Then, of course, well, they just went on and raised, and I had to confront all of these issues. And they're not being penalized. They're really not being penalized at all, because they've had the use of the money. And that's really what the judge said. Indeed, in TGIF, they even said the second section dealing with where they talk about not in good faith, etc. There's not a word about entitlement. They say the party who is entitled to, the judge may. Now they say that the judges have no discretion in entitlement, but the judge may have discretion in disallowing an award if they find that there was no good faith. But of course, the judge already ruled that there was no bad faith here, and TGIF says that. However, that provision, the good faith, bad faith provision, that provision is inapplicable because there was no evidence that the demand was not made in good faith.
Well, I think your opposition agrees that that's a condition subsequent. I don't think that's what we're arguing about. I think the central question, and if you said one thing about it, but just to be sure, your opposition is arguing that there was a dispute about whether the terms of the offer were clear enough to be so that the entitlement would arise.
Tallahassee deals with that, and it says that you're entitled to interest even though the parties continue to dispute entitlement. Tallahassee clearly says that. And if just for a moment, the co-counsel will make this. I do have some time left, a few moments.
You've got 2 minutes and 14 seconds.
But Tallahassee does deal with that, even though the parties continue to dispute entitlement and damages.
Maybe.
And that, if I might say also, that the Tallahassee case is also approved by the Third District in the Fishback.
Well, but you understand he's arguing that those cases were supplanted. You know, any teaching from those things was overcome when the statute was to require greater specificity.
May it please the Court, Your Honor. I'll be very brief. Just a couple of points. First point, offer was made in November of the year 2000. The fact that there was a determination in 2007 did not change anything to that offer. It was valid in November of 2000, and they could have contested it any time thereafter. They chose to wait. They took a gamble. How much was the offer for? $3,000. They could have just settled this case back in 2000 for $3,000. It would have been over with. But no, they chose to litigate, and the statute 76879 is there for that purpose, to punish people who don't want to settle. Their policy is, we'll settle nothing. That's our policy. We're not going to settle. Well, guess what? 10 years later, we're still litigating this case. And our courthouses are flooded. Foreclosures, flooding. Judges have to multiply their caseload by 4. Why? Because people don't want to settle? The statute was there to implement punishment if the parties don't want to settle. The 1996 amendments that they're referring to, the Supreme Court was asked to change those amendments to give judges discretion as to whether judges can determine entitlement. And the Supreme Court said, it's not our job to change that rule. It's the legislator's job to change it. If the legislator wants to give the judges discretion to determine entitlement, let them make the change. To date, there's been no change to that statute. To date, the statute says 2 things. You have a valid offer, which in this case, a valid offer was in 2000. And you need another thing, a judgment in excess of 25%. The verdict came back here, Your Honors, at $5.5 million. 2,000 times that amount. And with the remitter to $500,000, we're talking about a judgment that's 200 times the amount of the first offer. They should have took that offer, settled it, and moved on with this case. But we're here 10 years later, and there's still thousands of cases out there. And if you don't punish them, they'll do this on all their cases. And that's what the statute requires of you, to punish them, so that they don't do this, so that they change their policy of, we're not going to settle to, hey, maybe it's time for us to settle and put an end to this litigation. That's all I have to say.
Rebuttal? Brief rebuttal.
Jackie Mason was nailed for prejudgment interest from the birth of his child because the court held that that was the event that triggered entitlement, just like prevailing party status. The Supreme Court held in Nichols, State Farm settlement proposal was too ambiguous to satisfy Rule 1.442. It was therefore an invalid offer. They reaffirmed that in the Campbell case. Judge Salter, I have before me pages 2881 through 2885 of the record on appeal, in which we set forth our objections, specifically that the offer was not specific enough, that the offer didn't state the total amount of the proposal, the offer didn't state whether we had to settle all 3,300 cases in order to obtain the benefits, and, quote, these ambiguities render the demand for settlement made in French unenforceable to support an award of attorney's fees as a matter of law. We litigated entitlement, and we lost. I refer the court to the transcript of the hearing, which is what Mr. Weinstein was reading from. It's in the record. He was cited for the transcript pages. It's actually in the record at pages 3513 through 3520. And after our long argument in front of Judge Smith on all the reasons that are identified at pages 2880 through 85 of the record, the colloquy to which Mr. Weinstein refers occurred at the end of the hearing. Judge Smith asked whether we'd submitted all the papers, everything we wanted to argue. And she said, I have defendant's memorandum of law in opposition, which is what I was just citing from. And she said it would be helpful to get another copy. And then she said at the end, and just so it's clear to everybody, you do agree that if I rule that there's nothing other than the proposal itself in this case, that I should consider the proposal, I should consider that the proposal itself does comply with the rule. And Mr. Riley said, right, if nothing else happened. We obviously didn't at the end of the hearing all of a sudden surrender our objections to the validity of the offer. So this is what it comes down to, all the bombast aside. The court needs to decide whether or not it agrees with the Second DCA's Hill decision that entitlement under the post-1996 version of Rule 1.442 occurs when a trial court determines that an offer is valid if indeed proper objections have been made to the validity of the offer solely for the purpose of triggering prejudgment interest, which of course, even if we should be punished, prejudgment interest is not punishment, and of course because we were hit for fees during all the time that we were litigating entitlement. Thank you.